Okay, let's go ahead and we'll get started. Again, my name's Amy McCulloch, and I'm from the Lighthouse Group. I work in our Employee Benefits Department, and I certainly would like to thank everybody for taking time out this morning to join us for our webinar. This webinar is intended to give employers the key updates on the new pay-or-play and reporting regulations under the Affordable Care Act. So I'm very excited to introduce our key speakers for this morning's webinar, Mary Bauman and Tripp Vander, both from Miller Johnson. And I'm going to give you some information about their background, and then we'll go ahead and get started. So Mary is a member at Miller Johnson in Grand Rapids, Michigan. She works with employers in establishing, amending, and terminating employee benefit plans of all different types. Ms. Bauman is the chair of the firm's Employee Benefits and Executive Compensation Practice Group and Healthcare Reform Team. Ms. Bauman is recommended by Chambers USA for Employee Benefits and Executive Compensation and is listed in the Best Lawyers in America for Employee Benefits Law. Other recent honors include being recognized as Michigan's Super Lawyer, a 2012 Client Service All-Star by BTI Consulting, Most Influential Women by the Grand Rapids Business Journal, and A Woman in the Law by Michigan Lawyers Weekly. Tripp Vander is our other speaker this morning. He is an associate in the Employee and Benefit Executive Compensation Practice Group at Miller Johnson and an active member of the Healthcare Reform Team. He earned his JD from Michigan State University College of Law in 2011. He has a master's in accounting from the University of Michigan Stephen Ross School of Business and a BA cum laude in 2005 from Hope College. I didn't know that, Tripp. I'm a Hope College grad, too. I'll throw that in. He is currently licensed to practice in Michigan. Mr. Vander is also a CPA and came to Miller Johnson from Platte Moran, where he was in the tax department. He did an internship with the IRS as Chief Counsel in 2009. He is a member of the State Bar of Michigan, the Grand Rapids Bar Association, the American Institute of Certified Public Accountants, and the Michigan Association Certified Public Accountants. So without further ado, I'll hand things over to Mary and Tripp. And again, I thank everybody for joining us this morning.
Thank you so much, Amy. It is a pleasure for us to join you on the call this morning. As Amy mentioned, we're going to really talk about two things today. First, we're going to focus on the pay-or-play, and then we're also going to talk about the new reporting regulations that just came out in February. We have really a wide variety of clients on the call today. We've got some of you are smaller, some of you are larger, some of you are municipal governmental, some of you are nonprofit, and some of you are for-profit. We're going to try to provide feedback and comments that might impact many or just some of you. So be a little bit patient with us, please, as we kind of go through that. So here we go. As you know, on the pay-or-play regulations, they were originally, of course, set to take effect in 2014, but they were delayed. And we just received final regulations about the pay-or-play in February. Those regulations modified some earlier regulations that were issued more than a year ago, plus intervening IRS guidance. As you know, the penalty applies to large employers with at least 50 full-time employees and full-time employee equivalents. How you determine that is you look back. So for a calendar year, you look back and see were you a large employer during the prior year. Generally, you're looking at the entire 12 months, and you're figuring out your average employees on a monthly basis. But for the first year, if you want to do this on a shorter time frame of 6 consecutive months, you may do so. So those of you on the call today that are under 50, there are some specific rules in terms of how to figure out if you are a large employer. And as I mentioned, the pay-or-play was set to take effect in 2014, but the infamous IRS blog right before the July 4 holiday announced that the IRS decided to push the effective date back to 2015, and so we do have this additional year of relief. Now, there are two penalties under the pay-or-play. I call them the $2,000 penalty and the $3,000 penalty, and we've tried to put them on 2 slides for you just so you have all the detail together, but we do apologize for the amount of detail on the slide. The $2,000 penalty applies where the employer basically doesn't stay in the game. They don't offer health coverage to at least 95% of their full-time employees and their dependent children. Now you notice it's only full-time employees, it's not full-time employee equivalents, and it's not spouses, it's just dependent children. And if the employer doesn't do this, and at least one of their low-income full-time employees receives the premium credit, and remember full-time for this purpose is somebody who works 30 or more hours a week, then the employer has to pay an annual penalty of $2,000 multiplied by all of its full-time employees, irrespective of whether any of the rest of them go to the exchange, disregarding the first 30 full-time employees. Now, dependent children, as I mentioned, have to be included. Tripp, how does this work?
Well, the recently issued regulations provided some important clarification about offers to dependent children. And I think some of the key takeaways is, well, dependent children, the definition includes natural-born and adopted children. It does not include foster and stepchildren.
Was that originally thought to be the case?
I don't think it was clear in the original regulations, but yes, it was originally, okay, I take that back. That was originally not thought to be the case. So that is an important clarification. I think the other important point to know is where healthcare reform previously extended dependent coverage until age 26, which meant the child's 26th birthday. In order to avoid the pay-or-play penalty, the offer of coverage actually has to be extended until the end of the month after the child turns 26.
Now, does that take effect right away, Tripp?
No, this will take effect when the pay-or-play regulations take effect for your employer. So at earliest, January 1 of 2015, but as we will discuss in a few slides potentially later if you qualify for some transitional relief.
And isn't there something about a little bit of relief on that end of the month thing if I'm taking steps to comply or something?
Yes, as the final regulations also gave another bit of transition relief that says if I don't offer coverage till the end of the month for my dependent children of which they turn 26, then as long as I quote-unquote take steps to comply, I get an additional year before I actually do have to comply with that rule.
And that could just be thinking about it.
Yeah, I suppose.
Okay. Then the second penalty is the $3,000 penalty. So if I am a large employer and I do offer coverage to at least 95% of my full-time employees, but the coverage that I offer either isn't affordable or isn't of minimum value, and I have a low-income full-time employee who receives the premium credit, they go to the exchange, they don't take my coverage, they go to the exchange, they get the premium credit, then I have to pay an annual penalty of $3,000, but I only pay it on the employees that actually do that. They actually go to the exchange, they actually get the premium credit. And by the way, this penalty is capped at the $2,000 penalty, but it should be a much lower amount because it's only for the people that actually go to the exchange. Now, affordability was defined by the proposed regulations that were issued more than a year ago, and it really is keyed off of the employer's least expensive medical option, and it's also keyed off of single coverage only, just the employee only coverage tier, and it can't exceed 9.5% of the employee's pay. And for this purpose, there are 3 safe harbor methods to determine affordability. One is you look at Box 1 W-2 pay, and that is for the year. So for measuring affordability for 2015, we would look at the Box 1 W-2 from 2016 that's issued in January of 2016, or the employee's rate of pay, or the federal poverty line for a single person. Tripp, did the new regulations that just came out impact any of those safe harbors at all?
Well, there was no changes to the safe harbor, but there was some clarification. So first of all, with respect to the rate of pay safe harbor, the original regulations indicated that if I was going to use the rate of pay safe harbor, throughout the year I could not decrease my employee's rate of pay and still rely on that safe harbor. The final regulations clarified for hourly employees only, if I do decrease their rate of pay throughout the year, I can still rely on the rate of pay. However, rather than taking a snapshot of that rate of pay at the beginning of the year and using that amount through the entire year, I'm going to look at the rate of pay for each particular month. The other clarification relates to the federal poverty line safe harbor. So the final regulations clarified that I can use the federal poverty line safe harbor that's in effect on the first day of the plan year, or more importantly, up to 6 months before the first day of the plan year. And that's really important because if you are going to use the federal poverty line safe harbor, having that number 6 months in advance of your plan year helps for planning purposes during open enrollment and how much you're going to set your employee contribution at.
Mm-hmm. Yeah, and I think right now, if you don't charge more than about $92 a month for single coverage under your cheapest medical option, you would comply with the current federal poverty line for a single person.
That's correct. And I guess another point of clarification, if you do have a calendar year plan, this guidance is almost necessary because the federal poverty lines are not usually reduced until released until the end of January or early February for that particular year.
Oh.
So the 2014 federal poverty guidelines were not released till, I believe, end of January of 2014.
Okay, very helpful. And then also you'll notice on this slide that the cost of dependent coverage is disregarded for purposes of the affordability test for under the $3,000 penalty. So, you know, if I decide to charge 100% of the cost of dependent coverage, that would not penalize me for purposes of the $3,000 penalty. Tripp, do you see that changing at all?
I don't believe so. I believe that would actually require statutory change.
I believe I agree with you on that.
Which would require an agreement between the Congress and the President, which is few and far to come by these days.
I think you're right. And then the last test, the minimum value test, basically means that the plan pays at least 60% of the total allowed cost of benefits under the plan. That's when you're looking at things like deductibles, co-pays, co-insurance. And my guess is that when you chat with your Lighthouse consultant, my guess is the overwhelming majority of you, in fact, maybe all of you, offer a minimum value plan. So that's not usually where the action's at. The action's usually focused on the affordability test. Now there is a very important transition rule that was provided by these brand new regulations, and that is if my employer is at least 50, but not more than 100, in that 50 to 99 range of full-time employees and full-time employee equivalents, I can qualify for 1 year of additional relief from the pay or play, where it wouldn't apply to me until 2016. Now, I can't play games to get there. I can't reduce my workforce after the regs were initially published in the Federal Register on February 9, sometime through the end of this year, to reduce my workforce just to qualify. And I can't eliminate or materially reduce health coverage in order to qualify after February 9 either. And that's really focused on things like who is eligible, how much does the employer contribute toward the cost of coverage, issues like that for this year. And then I also have to provide some type of certification that I qualified. Tripp, is there some type of form on that?
There will be, but as of 11:30 last night, when I checked last, the IRS had not yet published a certification form that should be used. So I imagine that will actually be a fairly popular event that will not necessarily go under the radar when that does happen.
Yeah, I agree. I agree. So what about large employers? When I say large employers, I mean those who are 100 or more full-timers. They do have to comply with the pay or play starting in 2015, but they do get 2 new transition rules to take advantage of for the first year. One is, remember how I mentioned that on the $2,000 penalty you had to cover at least 95% of your full-timers? Well, now, just for the first year, you can avoid the $2,000 penalty if you only offer coverage to 70% of your full-timers. That's just for the first year. And then also for the first year, if you are subject to the $2,000 penalty, you can disregard the first 80 full-timers rather than the first 30 full-timers when calculating the penalty amount. And that's really kind of in recognition of the mid-sized employer relief, because obviously they get relief on their workforce as well. Non-calendar year plans. And of course, a lot of you might say, well, what is my plan year, Mary and Tripp? What is it? Well, believe it or not, the regulations didn't define plan year for this purpose specifically, but but they seem to infer that if employees elect their benefits on a cycle other than the calendar year cycle. So let's say you have open enrollment in May and employees elect benefits and their new benefits are effective June 1. That appears to be what they're talking about. So it's not your 5,500 year, it's not your renewal year necessarily or your deductible year necessarily. We're really looking at the benefit election year. Now, if you don't operate your plan on a calendar year basis, it appears that you can qualify for some transition relief to delay the pay or play until the first day of your 2015 plan year, but you have to satisfy some requirements. And the first one is your plan had to be in existence on a non-calendar year basis on December 27, 2012. Tripp, so in other words, this eliminates some employers from relief right out of the gate.
Yeah, so if you have a non-calendar year plan that you recently switched the plan year for whatever reason, if that switch hadn't been made by December 27th, 2012, then for the next couple of slides, you don't need to pay attention because this relief won't apply to you at all.
Or if it's a new plan.
Or if it's a new plan. So if you are a relatively new employer and you started your plan sometime after this December 27th date, then again, you will not qualify for the non-calendar year transition relief.
Yeah, so that's unfortunate because I think a lot of employers who operate on a non-calendar year plan year basis just kind of assume that this relief applies to them. So if you were in existence on that magical date of December 27, 2012 and haven't, amended your plan, the good news is under transition rule number 1, it's really kind of automatic. You get relief then for anybody who was either enrolled in your plan or eligible for your plan on February 9, 2014. So for all those people, you don't have to worry about the pay or play until the first day of your 2015 plan year. But let's say that you define eligibility as only employees who are full-time, and my current definition of full-time is somebody who works 36 or more hours a week. What about those people that work for you in the 30 to 36 hours per week range? Does this transition rule apply to them? No, because they weren't eligible under your plan under its terms currently. And so how do we get transition relief for those people? Well, the IRS in these proposed regs has provided 2 alternatives, transition rule number 2 and transition rule number 3. If you satisfy one of them, you get transition relief for basically all of your folks. And under the first rule, you would say, did I actually cover all, meaning all, not just, that's all my part-time, everybody. Did I cover at least all of my people under my plan sometime in the past year? When I look back from February 9, 2014 back. Sometime during that time frame did I actually cover everybody? Or during the most recent open enrollment period that ended before February 9 of this year, so my most recent open enrollment period, I offered coverage to at least a third of all of my employees. This is very similar to the transition relief under the proposed regulations issued more than a year ago. But this alternative transition rule number 3, is new, and it says that we're, instead of testing based on all your employees, we're testing on the basis of all your full-time employees. And again, we're either saying we're at least a certain percentage covered or at least a certain percentage offered coverage under the similar reference, only we're using slightly different fractions because we're keying this off of full-time employees rather than all employees. Tripp, why did they add this?
Well, this was actually to give relief to more employers that wouldn't qualify under transition rule number 2. So if you're an employer that, say, has, for example, a larger number of part-time employees or seasonal employees that you don't offer coverage to, then it was probably difficult, if not impossible, to pass the 1/4 or the 1/3 percentage test in transition rule number 2. So this really is an extension of that transition relief to those employers and allows some of these employers that have those large numbers of part-time and seasonal workers that don't qualify to also qualify for this transition relief.
So the IRS was actually trying to be nice.
It appears so.
And I know of folks that this seems a bit dizzying, but what I guess I would say to you is if you are a non-calendar year plan, you're going to want to make sure you qualify not just under transition rule number 1, but also 2 or 3 if you currently don't define full-time as somebody working 30 or more hours a week, and you don't offer coverage to all your folks who work 30 or more hours a week. And it's important for you to actually go through the analysis to make sure you qualify, because if you don't, you're not going to have comprehensive relief. So that's an important transition rule. Now, one of the other things that they did in the new final regulations that just came out was they wanted to emphasize that when we measure for determining whether somebody is full-time working 30 or more hours a week, we have our look-back measurement period and stability period that I'm sure is near and dear to all of your hearts on the call today, because my guess is most of you have read, gone to seminars, webinars, and thought about all this, and that structure is still there. But in addition, the other thing the IRS did in these final regulations was they said, you don't have to use that measurement period if you don't want to. You could also say, we're going to measure for full-time status on a monthly basis. And for this purpose, we would say anybody who works 130 hours for the month is considered full-time. The problem with the monthly measurement period, the simplicity of the monthly measurement period is you're just looking at the month, and you're saying 130 hours, which means 4 1/3 weeks. That's the IRS average for the month. But the disadvantage of the monthly measurement period is if you didn't offer coverage to somebody who you didn't think was full-time, and you get to the end of the month and you realize they were, you have to retroactively offer them coverage back to the first day of the month in order to avoid the pay-or-play penalty. That seems pretty difficult to do. And so for that reason, I anticipate that the majority of you, in fact, the overwhelming majority of you, will probably instead gravitate toward the look-back period and measurement period, because, of course, there you look back, and if somebody meets the average for the measurement period, then you get to rely on that determination for the future subsequent stability period. And remember, there are look-back measurement periods available for certain new hires, not all new hires, but also all ongoing employees. And now we're going to kind of get into that a little bit. This is similar to the framework from the proposed regulations. So that's the most important thing for you to understand, is that this is really building on those regulations, doesn't significantly change them. So if I am a new hire and I'm full-time when you hire me, meaning I reasonably expect you to work on average 30 or more hours a week, then for me, you can't subject me to a look-back measurement period. The hours that you count for making this determination are all hours working for all related employers. So for example, if I have 2 companies and they're commonly owned, and the person works 20 hours one week for one employer and 20 hours a week for the other employer, those hours are aggregated together, and therefore I am full-time. So if I am full-time under the pay-or-play, then you have to offer me coverage by no later than the first day of the month after I've worked for 3 months in order to avoid the penalty. Tripp, how does this interact with the 90-day waiting period rule?
Well, Mary, these rules are similar, but I think the easiest way to see the coordination between the 2 rules is where the pay-or-play regulations indicate which employees I must offer coverage to. The 90-day waiting period regulations actually say when I have to offer that coverage. So, for example, I don't have to offer my part-time employees coverage under the pay-or-play penalty. But if I do, I can't make them wait more than 90 days before they become eligible.
With coverage effective on the 91st day.
Correct.
And this, of course, is kind of crazy because it would suggest first of the month, basically after 90 days. So, kind of crazy.
Correct.
Tripp always agrees with me. It's great. It's great. Okay, so the other thing I want to say on this slide is, notice there are no exceptions for employees on short-term assignments, other than seasonal, which we'll talk about in a moment. So if you hire me on a non-seasonal basis and you say, I want you to do this one project and you're going to work for 4.5 months. For that person, I have to offer them health, and they're going to work on a full-time basis when they're doing that short-term assignment. You have to offer them health coverage pursuant to the second to last bullet on this page. Otherwise, you would pay a penalty on that person potentially for that gap period. So something important to keep in mind. Now, on the other hand, employees in other categories can be subject to a look-back measurement period before you would offer them coverage during a stability period. There are 3 categories: variable hours, seasonal, and part-time. And I should mention that the variable and seasonal were mentioned in the proposed regs. The new final regs also specifically mention part-time, which I think is really just a clarification. So who is a variable hour employee? It's somebody where you can't reasonably expect whether they're going to work 30 or more hours a week at the time you hire them. So the key is, what is my reasonable good faith estimate when I hire them? They might end up working more than 30 hours a week after I do hire them, but at the time, did I have a reasonable basis to think, no, they were really going to have variable hours? And factors to look at this from the regulations include, who are they replacing? Was it somebody who was full-time or somebody who wasn't full-time? The hours of workers in the same or comparable positions. Do they work full-time? And also, how was this job advertised or communicated in the offer or in the job description? Was it communicated as requiring 30 or more hours per week? All of those factors come into play in determining whether somebody was variable hours. Seasonal employees also can be subject to the initial measurement period. And a seasonal employee is somebody who works typically no more than 6 months a year. And also their employment period starts at approximately the same time each year. So if I'm an employer that says I hire people every month of the year and they're all seasonal, that may be a hard sell in the eyes of the IRS. It really is something like, no, I typically hire people in May or June, and I hire them for the summer. That's a more defensible position. Tripp, what about the type of work? Are there certain industries that I must be in to be seasonal?
For seasonal employees, no. Unlike seasonal workers, which is actually a separately defined term under these regulations, which apply to when you're determining if you are or are not a large employer, you do not need to work in a certain particular industry like agriculture or retail during a holiday season in order to be classified as a seasonal employee.
Yeah, so I think that's very helpful. So any employer could potentially have a seasonal employee. One question, Tripp, that I've been asked a lot is, can student interns qualify as a seasonal employee? What do you think?
I certainly think that it's not clear, but I would say that there's a reasonable argument because they probably do work typically 6 months or less during the year, which I'm assuming would be the summer, and that employment actually is during the same time each year if it's, for example, a summer intern.
Right. On the other hand, if I really like my summer intern and I say, oh, let's just have you stay on year-round, that might be a problem.
I think that's where you do cross into a problem area.
Yeah. And then finally, part-time. If I hire somebody and at the time I hire them, I really know that they are going to work less than 30 hours a week, I can also subject them to this new initial measurement period. Now, the initial measurement period has to be somewhere between 3 and 12 months long. And during that period, the person has to average 30 or more hours per week. And if I meet the test, then you have to offer me coverage during the subsequent stability period. Otherwise, I could be subject to the pay or play with respect to that individual. So here's an example. This is very, very similar to the old proposed regulations. So I have a seasonal employee. I hire them on May 14, and my initial measurement period for this person, you'll notice, is the first day of the month after their date of hire. I could start the measurement period on their date of hire, or I could start it, for example, on the first day of the first payroll period on or after their date of hire. But the reason that I like starting this on the first of the month after their date of hire is because then you can capture all new hires during the prior month and test them all together. Otherwise, you could be looking at, 365 initial measurement periods if you hire people every day of the year. This way, you're only having 12 of these during the year. And then if they do complete that measurement period, we have an administrative period that can be for a month. It could be longer, but in no event can you extend offering them coverage beyond the last day of the month beginning on or after their anniversary date. And so for this person, if they do meet the test, you have to offer them coverage by no later than July 1 of 2015, and it has to be at least 6 months long and at least as long as the measurement period. Tripp, once again, how does this all interplay with the waiting period regulation?
I think the easiest way to look at this is really an exception to the 90-day waiting period regs. So if you have a seasonal or a variable hour employee that you are going to subject to initial measurement period, you get this initial time of using a up to 12-month measurement period and then an administrative period before coverage. So again, rather than having coverage start at least on the 91st day after their start date, this is an exception to that rule.
Okay, good. Then remember, all ongoing employees can be subject, including full-timers, can be subject to a measurement period every single year before you would offer them coverage for the following year. So that's another option. And here again, this is very similar to the old regulations. Here we have a large employer in this example that operates their plan on a calendar year basis. They've decided that their standard measurement period is going to be November 1 through October 31. I should mention that they could also start this on the first day of a payroll period, or they could start it in a manner that would end on the last day of a payroll period. So there's some flexibility there. And then this employer is going to have an administrative period of 2 months, and they can have any administrative period. It could be like 2.25 months or 2.5 months, but it can't exceed 90 days. That's the key. And of course, 90 days typically takes a 3-month administrative period out of the running. And that's intentional. The IRS has said that. And then we have a stability period that has to, once again, be at least 6 months long and at least as long as the measurement period. So in this example, it's got to be at least 12 months long. And so the stability period, by the way, the first one, should always start on the first day of the plan year. So for employers that are large employers with 100 or more full-timers, their first stability period is going to start on the first day of their 2015 plan year. Now, there is a transition rule that will allow employers to use a shorter measurement period just for the first year, if they would like. It can be as short as 6 months long. It could be 7 months long, 9 months long, whatever. But it has to begin by July 1, 2014 as well. Tripp, why would an employer want to do this?
Well, if for no other reason than the fact that it gives you more time to comply with all of these regulations. That may be reason enough itself. The other reason is it gives a potential planning opportunity. So if you're an employer that has maybe off-peak seasons where your employees aren't working as much, you can try to capture that 6-month period in that off-peak season. This may reduce the amount of full-time employees you have, at least with respect to who has to be offered coverage in 2015. Of course, again, the 6-month rule only applies the first year, so this would be a one-time opportunity.
So, Tripp, in other words, they could maybe play around with this and say, I'm going to try a 6-month long period, a 7-month long, a 9-month long, and 12 months, and kind of see how it stacks up?
Correct. As long as those, as long as you meet the rules, and one being that they are a consecutive 6 months, and that they start, by July 1 and end no earlier than 90 days before the start of your plan year.
Yep.
That is correct.
So it's a planning opportunity. Okay, so there's just an example of that, how this would work in the example that I just gave you. So instead of starting that measurement period on November 1, 2013, they could start it as late as May 1, 2014 under this special transition rule. But again, it's just for the first year. Now, one size may not fit all, and what I mean by that is you may decide that you don't want to have the same measurement period either of terms of when it starts or stops or how long it is for different groups of your employees. A great example of this is salaried versus hourly. Maybe you pay salaried folks every 2 weeks or bi-monthly, and you pay hourly workers once a week. You may want to have your measurement periods be a little bit different for those two groups of employees to capture and recognize those payroll periods starting and ending dates. Some other examples, you might have employees working in different states, or maybe union versus non-union workers, or even union versus union workers. And finally, of course, if you have different employers in your what we call controlled group of related businesses, you could test on a large employer by large employer basis. But no other divisions would be possible. These are the only ones in how you can slice and dice your measurement period. Transfers. This is a little complicated as well. If I transfer an employee during the initial measurement period, either I do it as the employer, or maybe they apply and they get to do it from a non-full-time position to a full-time position, I have to offer that person coverage by no later than the first day of the 4th month after the transfer in order to avoid the pay or play. But interestingly, if that transfer occurs later, after their first year, I could wait until the first day of the stability period as of which they were eligible based on the look-back period. So it's kind of crazy, isn't it? I might have to automatically offer coverage to a new hire if they transfer in the first year, but for somebody that's maybe been with me on a part-time basis for several years, I'm not required to transfer them right away to a eligible full-time position for health benefits. I would think maybe from a human resources perspective I would want to, but I am not required to, interestingly, under the pay or play. Now, what about going the other way? What if I transfer from a full-time position to a less than 30-hour position? What are the rules there? Well, again, for that person, if I transfer to a part-time position, but I'm still working for you, I would still be eligible based upon my look-back period and the stability period that I'm in. So in other words, I might not be able to eliminate your health coverage until the beginning of the next stability period where I didn't meet the 30-hour test for a look-back measurement period. And of course, that may depend on what time of the year I had that transfer. It could depend on what my hours were before and after the transfer. Kind of crazy. Now, there is a special rule in the new regulations that would allow you to basically convert that person to a monthly measurement period when they did transfer, and then to measure their hours for 3 consecutive months. And if for 3 consecutive months they didn't meet the 130-hour test, then I may be able to reduce their coverage at that time. But once again, that's giving them 3 months of continued eligibility. Tripp, why did they add this rule?
Well, Mary, I actually think this is a fairly complicated rule that may have little practical use, but the regulations did give examples of where this may be useful, and that's in a situation where an employee has a phased retirement, so over a longer period of time is slowly reducing the amount of time that the employee works. Another example that the regulations gave was when an employee switches to part-time to take care of another family member that's aging. So again, it's almost like the regulators came up with these examples and tried to back into a rule about how to address these specific situations.
Yeah, I think the important thing to remember on the call today is that, currently if somebody goes from full-time to part-time and you don't offer part-time employees health coverage, you would immediately terminate their coverage or maybe terminate it on the last day of the month. You're not going to be able to do that anymore if you're a large employer under the pay or play penalty. And that's, I think, the key takeaway. Now we move on to the lovely topic of hours of service. So when we figure out whether you're full-time or part-time, what we're looking at is the hours that you are paid and you work, that makes sense. We also look at the hours that you're paid but you're not working. Maybe you're on vacation. Maybe you're on a paid leave. Those hours also count. But then on top of that, we also have to count the hours that you're off of work and are not paid if it's due to FMLA, USERA, or jury duty. How does this work, Tripp?
Well, in the unpaid leave for FMLA, USERA, and jury duty are the same rules that apply to educational institutions when they're calculating their employees' hours over, for example, a summer break. There's really two methods of calculating these hours for these unpaid leave periods. But for all practical purposes, and the regulations did clarify this, the two methods are going to yield the same result. So essentially what you are going to do is you are going to exclude this time when calculating the average. So for example, if I use a 12-month or 52-week measurement period, and I have someone that is gone on FMLA leave for 2 weeks, I'm going to calculate their average over the 50-week period and totally disregard the 2 weeks that they're gone. So essentially, the fact that they're not working at all in the 2-week FMLA period cannot reduce their average over the course of the entire measurement period, and then have the effect of making them not qualify as a full-time employee.
There you go, folks. And that's pretty much the same structure from the regulations that were issued over a year ago. And then for salaried people, you have to actually track their hours, their actual hours, which of course some of you may already do and some of you may not, which is difficult. And if you don't, they do offer up a couple of equivalency methods where you can credit them with either 8 hours for every day they are credited with an hour, or 40 hours for every week that they're credited with an hour. So if you've got a bunch of people that are part-time salaried working for you, 3 days a week, the equivalency method, 8 hours times 3 is 24 might work beautifully for you. But then if you've got another part-timer that works for you, 4 hours a day, 5 days a week, that's not maybe going to work out so well for you. So you got to take a look at that. You can use different methods for different groups of categories of employees as long as they are reasonable. So maybe you say, salaried workers in my corporate office, I have one rule. Salaried workers in the field, I have another rule, something like that. Now, there are some special categories of employees, and I realize that these don't apply to everyone on the call, but based on the sign-up, it looks to me like they apply to some of you. One is volunteer employees. If I am a volunteer and I work for a governmental employer or a tax-exempt employer, I potentially can be disregarded for purposes of the pay or play as long as you're not giving me more money than basically reimbursing my expenses and some type of other reasonable or nominal fee. So if you're giving me a very, very small amount, but it's got to be really nominal. That's one special category. Another special category is student employees. And again, I think I have some folks on the call that this applies to. If I am working on a federal or state or local work-study program, those hours may be disregarded. But it doesn't work for other types of work the student works. So Tripp, what wouldn't count for purposes of this?
I think the important distinction that it gave with student employees is student interns and externs. So if I have a paid student intern or extern, then you have to include their hours of service. So if they are working 40 hours a week, these paid student interns or externs are going to qualify as a full-time employee that need to be offered coverage. The important clarification is if you have unpaid student interns or externs, those hours do not have to be counted.
Right, and as we mentioned earlier, if I am a student intern and I'm seasonal, then I might be able to subject that person to a measurement period before I'd have to offer coverage, which would probably result in me not having to offer them coverage. Another special rule that does apply to a few folks on the call today is regarding adjunct faculty members. One, it's really hard to figure out how to track hours for these people because they're adjunct and they work crazy schedules. So there is a safe harbor that was offered up in the regulations for at least 2015 where you can credit adjuncts under a formula, which is 2.25 hours for each credit hour that they teach each week, plus an hour of service for every week that they are required to perform other duties, like required office hours or faculty meetings. Now, Tripp, is this required that they have to follow this?
No, this is a safe harbor. So if you have another reasonable method of tracking adjunct hours, faculty member hours, you can use that method. However, if you do choose to use the safe harbor, the IRS is going to treat you that you did it properly. You don't have to worry that maybe your method was unreasonable.
Yeah, thank you. Another category which may apply, I think, to a few folks on the call today is regarding on-call employees. That's another difficult one. How do I track your hours? Well, what they've said is you can use any reasonable method, but that reasonable method must include every hour that they are paid, every hour that they are required to be on your premises. And then this third one I think is a little crazy. Each hour for which their activities are significantly limited because of being on call. And of course I laughed because I thought, well, what if one of the requirements is that maybe I can't drink? Does that mean I get a 24/7 on that? I don't know, Tripp.
I think reasonable minds could disagree.
Okay, now we get to another kind of complicated topic, and that is rehires. What the final regulations do change the earlier rules a little bit. What they do say is if I am an employee and I have a break in my hours of credited service, I don't have to necessarily terminate or be terminated, but I have a break in hours of service of 13 weeks or more, then you can treat me as a new employee when I come back. The old reg said, however, I think used 26 weeks, did they, for everybody, and the new regs say we're going to keep that at 26 weeks, but just for educational organizations. And then the new regs continue the rule in the proposed regs, which is called the rule of parity. This is optional. You can follow it if you want to, but you don't have to. And this rule kind of focuses on, well, your period of employment your period of absence is at least 4 weeks and exceeded the length of the employee's prior employment. So let's say I worked for you for 4 weeks and I'm gone for 5 and I come back. Under the rule of parity, you could treat me as a new hire when I come back. Tripp, why is this important?
Well, I think this is another example where the IRS is trying to be nice to employers. So if I have an employee leave and then come back now within the 13-week period, if that employee was a full-time employee and I had been offering them coverage, then I essentially have to give them coverage effective immediately when they're rehired. So under the previous regulations, I had to do this if the employee came back within 26 weeks, assuming the rule of parity didn't apply. Now the IRS has shortened this down to a 13-week period, unless, again, you're an educational organization.
Okay, now we're going to move on to staffing agencies. This is a real hot-button issue. And the regulations, unfortunately, didn't give us all the detail we really wanted. What they basically say is, whose responsibility is the employee where there is a leasing company, staffing agency, PEO involved? Is the staffing agency, leasing company, PEO the employer, or is the customer, the client, the employer? And what the IRS said is, who is the common law employer, meaning who has the right to direct and control the activities of the employee? That's who the employer is for purposes of the pay or play, which seems to suggest that most customers will be the common law employer as opposed to the staffing agency, leasing company, or PEO. And I think that most folks think it should be the other way around because that's why they're using a PEO or a common law, a staffing agency in the first place. So it's very, very frustrating. And we're waiting, I think, on more guidance for this. But there was a very, very helpful piece of relief in the final regulations, which said if the staffing agency offers a health plan, and the health plan, and if somebody that is one of the staffing agency employees elects the health plan, and the staffing agency charges the client employer something more for that person, could be $1. Then it will be considered an offer of coverage by the client employer for purposes of relieving the employer of the pay or play penalty. Now, this is only required to be an offer of coverage. Excuse me. It doesn't say anything about whether the coverage is of minimum value or affordable, but it's something that you're going to want to look at. You're going to want to look at what staffing agency contracts do you have? What are their terms? Does the staffing agency offer health coverage? Do they charge you something more if anybody enrolls in it? This is something that you need to get a handle on moving forward under the pay or play. Now we're going to move on to the final reporting regulations. These were just issued last month, and they you're going to sound really smart to your friends if you talk about them as 6055 and 6056 reporting. Those are the sections of the Internal Revenue Code that were monitored. They are regarding individual mandate reporting and pay or play reporting. Tripp, I don't think I asked you right here, but do you want to comment on maybe the background or why these were added or what the purpose is in terms of individual mandate, employer pay or play?
Well, I think the names somewhat speak for themselves, or at least the names that we've given them. So the 6055 reporting is for purposes of assisting the government determine which people have actually enrolled in coverage and therefore satisfied their obligation under the individual mandate. So you remember under the individual mandate, if I don't qualify for certain exceptions, I have to have health coverage or I myself have to pay a penalty. So at least for employees that enroll in their employer's plan, this will assist the government in enforcing this individual mandate obligation. And then obviously the pay or play reporting is to assist the government determine which employers out there are large employers and offering coverage to their employees. I think a secondary purpose for the pay or play reporting is it will also assist the government administer the program of which individuals qualify for a premium tax credit.
Yeah, I agree. So the reporting is the first year, the reporting is due on an annual basis, and it's due during the first quarter of the calendar year after the calendar year to which the reporting relates. So it's a calendar year report, not regardless of how you operate your plan. And the first year that this is required is 2015, so that means that your first reporting will be in the first quarter of 2016. Now you have to report to the IRS and to employees. And so employees are going to receive a statement. It's going to be mailed to them by January 31. That seems a lot like W-2. It can be similar to the W-2. It's going to be similar to the W-2 and mailed along with the W-2. It can be. It doesn't have to be. Tripp, what do you suspect? We don't have the forms out yet, but what do you think this is going to look like?
Well, I think if we have anyone on the call that is in their company's payroll department, they're probably going to recognize this situation or be more familiar with it than others. And if you're not in the payroll department, go to your payroll department and have someone explain the W-2 process to you. I think it'll be very similar. So there will be a transmittal form that basically summarizes all of the forms that are passed out to their employees. So if you think about this, you are going to pass out a form that has all the information to each one of your employees, much similar to a W-2. That form is then also going to be filed with the IRS. Along with that form will be a transmittal form, which basically summarizes all the information on the individual forms. So again, I think at the end of the day, it's going to be a process that is very similar to the W-2 reporting requirement that comes every January.
And the other thing you'll notice here is that the reporting to the IRS is due by February 28 if mailed, or March 31 if filed electronically. And if you have over 250 employees, you have to file electronically. Tripp, do those dates also match up with the W-2?
No.
Oh, they don't. I thought they did. Ooh.
It's been a while since I've been involved in W-2 reporting, but I believe that's January, or I believe that's by January 31. Seems like we may have technical difficulties.
Okay. Okay. Sorry about that. We thought we had a technical difficulty, but we're going to keep going. We think we're okay. Okay, so look at that, Tripp. I learn something new every day. Okay, so if I'm a small employer that I have less than 50 full-time employees and full-time employee equivalents, obviously I'm not subject to the pay-or-play reporting because I'm not subject to the pay-or-play penalty. But I am still subject to the individual mandate, the 60-55 reporting. The good news is if I'm fully insured, the insurer is going to take that off my hands. So if you're on the call today and you are an employer of fewer than 50 full-time employees, you're not going to have to worry about this reporting with the pay-or-play, and the individual mandate you're going to be relieved from too if you're fully insured. Only if you're self-funded would you need to worry about the individual mandate reporting. Now, if you're a large employer, same thing. If you're fully insured, the insurance carrier is going to take care of the individual mandate reporting for you, but you are going to have to take care of the pay-or-play reporting. And the good news is, in the regulations that were just issued, if you are a self-funded large employer, you can report both the 60-55 and the 60-56 reporting requirements together using a consolidated report. So employees will only receive a single statement. They will not be receiving two statements from employees. So Tripp, any comment about these forms and how that works?
Again, I think if you are subject to the one reporting, you're going to use one form, and then the benefit is then if you have to do both the pay-or-play and the individual mandate reporting, you can do this on a consolidated basis, which then theoretically should be easier. I should point out, thanks to Google and iPhones, and Mary's really going to like this, I did quick check my previous comment, and she was right.
Oh my gosh.
She loves to hear that. So the deadlines for the 60-55 and the 60-56 reporting are going to be the same as the W-2 reporting, which would be March 31 if filed electronically and February 28 if filed on paper.
I'm so happy. Thank you, Tripp. Okay, so in other words, and Tripp, it does have his master's in accounting and has the CPA experience in his background. So Tripp, the 1095-C, we don't have the form out yet, but that's the employee statement form, so it will have to entirely be completed if you're subject to both 60-55 and 60-56, partially completed if you're just subject to 60-56. And then the 1094-C is what you mentioned, the transmittal form?
Yeah, so I would liken that to, again, back to the W-2 reporting process, the W-3 that is going to summarize all the information that's reported to the government, where the 1095-C is going to be the individual statement that's reported to all the employees.
Yeah. You probably are going to be putting together a little memo to your employees to accompany that 1095-C, because I think they're all going to be blown away and so confused when they get it. Okay. Now, what's crazy about this pay-or-play reporting, the 60-56 reporting, is that it has to include very specific information about employees on a month-to-month basis. How many months did they work for you? How many months were they offered coverage? How many months did they elect coverage? It is awful. But there are some transition rules, or I shouldn't say transition rules, some special rules to provide you with simplified reporting options. And the primary one is if employers provide full-time employees with a qualifying offer of coverage. Tripp, what is the rationale for this?
The qualifying offer of coverage, again, is just a luxury that the IRS is affording those employers that do provide coverage to mostly, if not all, of their full-time employees, and offer that coverage at a cheap price, being the federal poverty line affordability safe harbor. And so if you comply by those rules, then rather than having to report all this information on a month-by-month basis, now I don't mean that it has to be reported monthly, but the information has to be reported on a month-by-month basis, the employer actually only has to report it on more of a yearly basis.
And one of the things I know, Tripp, we've talked about is if I do qualify for this simplified reporting, there's going to be, what are they called, indicator codes? What's an indicator code?
Indicator codes, again, going back to the W-2 example, so you have codes that are A, or I believe One of the new codes that you're probably familiar with is the employer responsibility to report the total cost of coverage, and the code for that, I believe, is DD. So those, I think, is the indicator code concept that will be used on this reporting as well.
So rather than the dates of coverage or the dates they were offered coverage, you could just put EE, they were offered coverage the whole year.
Correct.
Something like that. So we're not going to go through the fine print on these simplified reporting options, but we do have a little bit more detail on this slide and the next slide. But the bottom line is, if you offer coverage to almost all your full-timers and it's affordable and of minimum value, this reporting is going to be much easier for you, and certainly the IRS, I'm sure, realizes that that is an incentive to employers, and there's no, I don't think, coincidence about that. So what is still missing? What are we looking for that you want to keep your eye on going forward? One, I think, is more guidance on tracking hours of service for folks that don't work on an hourly or salary basis. Any thoughts on that, Tripp?
I think a big question out there is commissioned salespeople. So many of you probably do have commissioned salespeople. How are we tracking those hours? Right now, the IRS just says you have to use any reasonable method, and it's not reasonable to basically only count hours that reclassify someone that typically works in a full-time position as a non-full-time employee. Going back to the adjunct professor formula, the 2.5 hours, remember that's a safe harbor that, at least right now, only applies for 2015. I anticipate that the IRS is kind of testing the waters with that particular formula and is going to determine over 2015 how that works and whether the formula should be increased or decreased. So I imagine that going forward we will get something more definitive that uses the same type of formula but maybe slightly modified.
And I think the other thing we're looking for, as I mentioned a little bit ago, is we still really need guidance from the IRS on who is the common law employer of employees, the staffing agency or the client employer for the pay or play. This is something that a lot of employers are really kind of agonizing about and trying to get their arms around. Another thing that we're waiting for guidance on is, you may or may not be aware that there's a catch-all penalty. It's an excise tax under healthcare reform. If you don't comply with something, maybe you don't amend for the 90-day waiting period rule, maybe you don't amend for providing first dollar preventive care if you're not grandfathered, maybe you forgot to amend for the definition of dependent child, maybe you're not getting your summaries of benefits and coverage issued. Whatever it is, there's this catch-all penalty of $100 per day multiplied by each affected individual. And boy, it would be nice to know who an affected individual is. Is it all employees? Is it only affected employees? What does that mean? So we would like to have some guidance on applying the penalty. And I guess the good news is that until we get that guidance, maybe we don't have to worry about that penalty so much. And then, of course, another issue that we're still waiting for are the non-discrimination rules, which apply to non-grandfathered, fully insured health plans. The IRS recognizes that those rules will not take effect until they issue regulations, and it doesn't appear, folks, that those regulations are set to be issued any time on the horizon. The last that we've heard from the IRS is that they're thinking about it, but they don't really have anything for it yet. So that's another one that we're waiting for. So what should your game plan be going out of the gate here? If you haven't figured it out already, first of all, if you're a small employer, you need to prepare to collect some data to evidence that. You have to be able to defend yourself if the IRS asks whether you're a large or small employer. So you need to actually look at your workforce and crunch some numbers and make sure that you're comfortable that you're a small employer. If you're mid-size or large, you want to determine what your effective date is. Do you qualify under the non-calendar year plan, your transition relief? And you also want to take a look at how those other transition rules would apply to you. The next step, if you are a large employer, is figuring out what you're going to do. Are you going to offer coverage to at least 95% of your full-timers, 70% for the first year? Is your coverage going to be affordable? And is your coverage going to meet the minimum value test? Tripp, should the employer look at affordability as an all or nothing requirement?
Not necessarily. I think, again, gives the employer some room for planning. So as long as you're an employer that's willing to accept some potential risk that you may have employees that qualify for a premium tax credit and then generate a penalty, you can pick a price that's affordable for a lot of the employees, maybe then doesn't subsidize them as much and saves the employer money, but then recognize that there may be some employees out there that go out there, qualify for a credit, and then generate a penalty. But if that penalty amount is less than the amount of your saving by setting a higher price, then that may be an appropriate way to go.
Yeah, I think particularly because we don't know, is every single person for whom coverage is unaffordable going to go to the exchange and enroll in coverage there?
They could easily have coverage through their spouse's employer or through any other source. And really, if they have coverage through another source, they're not going to be eligible for a premium tax credit. And without that premium tax credit, which is the trigger, there is no pay or play penalty.
At least on the 3. Yeah. Well, yeah. I guess on both. Yeah. So really, the key is to be a little bit thoughtful about this and realize that you have options. And then, of course, if you are a large employer, you have to consider whether you're going to adopt a monthly measurement period or probably more likely a look-back measurement period and a stability period. If you haven't done it already, folks, I know that many of you look to your outside resources like payroll vendors, your software, your other software sources, but my experience is that while many of them provide some help, most large employers still have to do a lot of the heavy lifting themselves because outside vendors really aren't thoroughly prepared on them. So you have to figure out, am I going to have a look-back measurement period and stability period for new hires and for ongoing employees? How is that going to work? What are my dates going to be? You need to map it out, and you have to figure out, are you going to do anything special in terms of a shorter measurement period for your first year? And are you going to have different rules for different groups of employees, or are you going to put everybody on the same cycle? And then, of course, the other thing you're going to need to look at is, how am I going to go about capturing hours? This is probably going to require you to work not just with your HR people, but your IT people, your payroll people, your finance people. You need to gather all of this information. If you don't have a way of tracking hours for salaried workers, that's going to be an issue. You aren't required to track hours for people if you want to assume they're full-time. But if you don't want to assume they're full-time, then you got to track their hours. So, and also don't fall into the trap of thinking, well, those people are part-time, so I don't have to track their hours. No, 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 no. You have to track their hours because you have to demonstrate to the IRS that they aren't full-time. So don't underestimate the importance of tracking hours. And then, of course, you may have some special categories of employees. We talked about adjuncts. We talked about commission salespeople. And, of course, what about those folks that you lease through a temporary staffing agency? Got to think about all of those people in terms of the pay or play. And then you need to make sure that you modify your health plan. There's nothing in the regulations that says that you have to do this, but remember that if you're subject to ERISA, your SPD has to clearly communicate your eligibility rules. And so if you're going to have eligibility rules that, for example, say you're not eligible until you complete a measurement period, if you're not a full-timer, then you better explain that. So you need to make sure that those rules are set forth in your SPD, and make sure that your SPD covers dependent children, natural born and adopted, until the end of the month they turn 26. At least making sure that amendment is in place by 2016. And then, of course, preparing for the reporting that we're all looking forward to the IRS and to employees beginning in the first quarter of 2016. So with that, I think we can now go to some questions. And Tripp and I will try to do the best we can. We here we've got some in the chat box, and we're going to probably take those in the order in which we receive them. If you have a question, feel free to type it into the chat box, and we will answer them as fast as we can. First question, if we are already offering health insurance to 70% of our full-time employees, well, they say and full-time employee equivalent, Tripp. Out of 150, can we set an hours cap like 40 hours and only offer health insurance to those that average 40 hours per week, even though that would be approximately 30 or so full-time employees that would not be offered coverage? Sounds like it would still be over the 70% requirement, but Tripp, does that have any impact on the $3,000 penalty?
Yeah, absolutely. So again, that would get you over the hump, so you wouldn't, if you're offering coverage to only people that work 40 hours a week, and that is 70% of your full-time employees using healthcare reform's definition, that gets you out of the $2,000 penalty. But you're still
for the first year.
For the first year, you've still got the $3,000 penalty to deal with, and if you hit that 70% on the mark, you've got 30% of your employees that could go out and get a premium tax credit, and then each one of them could generate their own $3,000 penalty.
Right.
So yes, it does get you out of the $2,000 penalty, but not the $3,000
Yeah.
penalty.
So for the first year. Okay. Next question. Can you clarify if I am a July renewal and I am a 65 employee sized group, will I have to comply as of July 1, 2016 or January 1, 2016? Again, renewal isn't necessarily the answer. And the reason I say that is some of you may renew with your stop-loss carrier if you're self-funded or your insurer if you're fully insured. Oh, that's true.
You actually, and I don't know if we clarified this
Yeah.
in our presentation, but if you are a mid-size employer and you have a calendar year plan, all of those calendar year transition rules, and this is a nice feature, you get to forget about those, because if you qualify as a mid-size employer, and that's again if you have between 50 and 99 full-time employees, then you're automatically exempt from these regulations until the first day of your calendar, or I'm sorry, of your first day of your plan year, regardless of whether that's a calendar year or non-calendar year plan.
Right, but I think the only thing I'm worried about there is the word renewal. Renewal could mean just that's what I'm renewing with my carrier. That isn't the answer. The answer really is plan year, meaning if I elect new benefits as of July 1, then yes, July 1, 2016. But if I am just renewing with my carrier and I give people elections some other time, that July 1 doesn't apply.
That is correct.
Okay, next question. What if an employee is paid per mile and not by the hour? They are not considered full-time because their hours are not looked at. Could they be excluded? No, they cannot be excluded. Tripp, how are we going to track their hours?
Again, I would imagine, again, the regulations only state that there has to be a reasonable method. So I think that a method is going to have to be determined and looked at.
Right.
how many hours these people are typically working in a day.
Right.
Obviously, these are drivers, so are they, do they have shifts? Especially maximum shifts that they can work in a day, and are they typically working those maximum shifts? And then how many days in a row can they do that?
I think that when they looked at the commission sales people as an example, which has a little bit of a correlation here, I guess what I would say to you is certainly you're going to give them credit for the approximate time they would be driving, right? So they're paid per mile, but we know that the miles can equate to something, and then you're probably also going to have to give them some type of credit for the hours to get ready to drive and the hours to stop driving. So in other words, there's a little bit of time at the beginning and the end of their shift or their period of employment. So that's a complicated one, but some type of reasonable method, and you can't exclude them. Next question, is it okay to have your administrative period overlap with your measurement period? Not really, no.
No, and for a practical purpose, I don't know if that you necessarily want to do that, because you're going to use your admin period to calculate who is a full-time employee, and if you haven't completed your measurement period, you can't do that yet until the end of the measurement period.
Right. So you can always look toward the end of the measurement period to see how you're doing, but your administrative period is not going to begin until after the measurement period ends. Okay, next question. We currently let employees stay on our medical insurance for 4 weeks or the first of the month following 4 weeks of a leave of absence. And I'm assuming that this is an employer that's maybe not subject to FMLA, because of course under FMLA they'd have to offer for 12 weeks. And after that they're required to go on COBRA. Will you need to change this? Yes, you will. If you are a large employer subject to the pay or play penalty, you are going to be required to continue to offer your employees coverage. But if they do go on a leave of absence and they stop working for you, you could stop their coverage then, but then if they come back, they need to have their coverage resume. Like, I guess maybe they don't have to necessarily change, but when they resume the coverage is dependent on whether they're a new hire.
I think another thing to point out, as you had mentioned, this employer appears not to be subject to FMLA,
right,
which probably means they're not a large employer.
Right, not subject to health care reform. Yeah.
Because I believe FMLA uses
50.
It's a different way to count, but it still uses 50.
Yeah, so if you're not subject to FMLA and you're not subject to health care reform, the pay or play penalty, I guess the answer would be no. Okay, under student intern, how would you view AmeriCorps students that are assigned to work for us? That's not a work. I don't believe. I'm not familiar with AmeriCorps, but I do not believe that that is a work-study program. And if it's not, you need to. And I'm assuming that you are paying them.
So they receive a stipend.
Stipend while they're with us. They get their assignments, but receive some medical coverage from the government. Well, if they receive medical coverage from the government, that is going to relieve you from the pay or play penalty, but you still have to offer them coverage if they are your full-time employees.
Yeah, I think these would be paid interns unless we're wrong in that they would be considered under a federal work study, and you would have to offer them coverage. But it seems impractical they would ever create a penalty because, again, they have coverage, so they couldn't get the premium tax credit, so they couldn't generate the pay or play penalty.
Right. And then we have a person that just wanted to review what the company size was for reporting under 6055 and 6056. Under 6055, all employers must report, but if you're fully insured, then your insurer will report for you. 6056 is only large employers subject to the pay or play. And by the way, if you are a mid-sized employer in that 50 to 99 range, you will have to do 6056 reporting, even for the first year, but you will have some special relief on how you go about doing that. It will be a little bit simplified. We have got all these crazy categories of workers, Tripp. Here's another one. Temporary traveling superintendents. They are hired per job, and they are not eligible for any benefits. This is outlined in their agreement. I don't think that we should really comment too much about this because one of the questions is, whose employee are they? Or are they independent contractors? They couldn't even potentially be an independent contractor, and then they're nobody's employee. So that's a pretty specific one that I think we would need some more detail on before commenting on. Next question. If an employer has a self-funded plan with an HRA, it sounds like it's an integrated HRA with a deductible component, will the 6055 form need to be filed by the employer for the HRA portion? Outstanding question. What do you think? It isn't addressed yet.
No,
it's not in the regs that we've got. I wonder if it'll be in the instructions in the form. That's a great question.
And I think it really gets to the point because, as Mary mentioned, now our HRAs have to be integrated with our health plan, but you can use the HRA to either, one, help satisfy the minimum essential value requirement, or potentially the affordability requirement. So if it is helping satisfy the affordability requirement, there may be a reporting component. But that is a good question. That has no clear answer yet.
No clear. That's a great question. Okay, next question. We're a large employer. We have a non-calendar year plan. Should we be tracking hours now of our 40-per-hour week employees, and when do we need to offer those who meet the equivalent? Okay. If you qualify under the non-calendar year relief, then your applicability date is the first day of your 2015 year, and that means that you're going to want to back up and have a measurement period that gives you the ability to have a measurement period and an administrative period both ending before the first day of your 2015 plan year. So depending on when that year starts, you may have to start tracking hours now. So the most important thing for you to do right now is diagram out when you want your first measurement period to start, and that's when you're going to have to start tracking your hours, and then you're going to have to start offering coverage as of the first day of your 2015 year. Okay, one of our businesses is a temporary staffing agency. Can you revisit the piece regarding who the employer is? Okay, this is a loaded question. We order physicals and drug tests and have the ability to terminate, but for all intents and purposes, the employer who contracts with the employee provides all direction and training. Most are placed with the employer, but the time frame of placement varies from 2 weeks to a year. This, again, is a very, very difficult question. I would say that for the most part, under the guidance that we have today, in my view, most of the time, the client employer will be the common law employer. There may be situations where you can argue that that is not the case. For example, where it's a truly very, very temporary position. I have fluctuations in my manufacturing needs, and I call people in for 1 or 2 weeks at a time. I don't know, Tripp, what would be another situation?
Well, not only that, but I think a correlation of that, if I am the temporary employee, if I am being, if I'm working all year round, but I'm working a few days here and a few days there and a few days there, 3 different, multiple employers, then I think because it would be, well, I think the control may still be at the client-employer. It's going to be hard to establish a client-employer or employer-employee relationship at the client because I'm only there for a very limited time. So then they're probably going to look to the staffing agency as the employer. But when you start getting into, I would say, 2-month placements and all these elements where you say that the client-employer is directing the employee, then I think it's reasonable to assume that the client is the common law employer.
Right, and I think also, what is the relationship? If in fact the client employer is looking to the staffing agency to basically be its recruiting arm, to say we want you to recruit people, we want you to interview them, we want you to do the physicals and the drug tests and vet these people for us, and then we're going to have them work for us for 2 weeks or 3 months, and then if they work out, we're going to hire them. That seems to feel more like they are the employees of the client employer, but it's not a clear question. Okay.
Goes back to the Fmla.
Regarding COBRA, we are considered a large employer because of common ownership. Okay. We are a controlled group, but we don't offer FMLA because the individual. Okay, gotcha. Well, so if you are a large employer, you are still going to be able to have that 4-week extension. But the issue is going to be, when do you have to offer coverage when the person comes back? If the person comes back within the 13 weeks or is otherwise not considered to be a new hire, you really have to resume their coverage right away by no later than the 1st of the following month. But if they are a new hire when they come back because they've had a break of, let's say, 13 weeks or more, then you could require them to complete a waiting period when they come back. So I don't think it impacts too much what you're doing now. It might impact what you're doing in terms of that next step of when they would become employees and eligible for coverage again. Another great question, Tripp. Long-haul truckers. They're paid on a percentage of their load, typically 70 hours and 8 days. Boy, oh boy, seems to me that you're going to have to, again, track hours using a reasonable method. And in terms of affordability, it's going to be based off of their pay, or you could, I guess, do the
federal probably would be the safest, but it's typically they work 70 hours in 8 days. That to me seems like they're a full-time employee. So if you were able to come up with a counting mechanism that treated these employees as a non-full-time, I think that's when the IRS said that's not reasonable because what you are doing is taking a position that is typically what we consider a full-time position and using an hours counting method to treat them as a non-full-time employee.
Okay, well, thank you. Oh, we got one more question. This is our last question that we're going to take, and then we have to sign off because we're out of time. Since we are a large employer, we have a non-calendar year plan. Is it correct to say that we do not have to be offering coverage to employees who have reduced hours under 40? No, The test is 30. The test for pay or play is 30. But once we determine our measurement period, we would track their hours to see if we would need to offer. And so you don't have to, if you're offering coverage only to people who work 40 or more now,
that's fine.
That's fine. But as of the first day of your 2015 plan year, you have to offer coverage to everybody who is working 30 or more hours per week. And one way to figure that out is to employ a measurement period preceding the first day of your 2015 plan year stability period, and that's how you're going to get your arms around that. Okay, hey, thank you all so much for joining us. We appreciate it, and again, we will be making available copies of the slides and a recording of this presentation on our website, www.millerjohnson.com, sometime tomorrow. Thanks again, and have a great day.